Colorado Supreme Court justices heard today that the pro-Trump mob beating police officers and storming the Capitol was not an insurrection because it didn't last more than 3 hours. Sounded like the warning from an erectile dysfunction ad, but it was an actual argument from Trump's attorneys in this nationally watched case of erectile dysfunction. Politics guy Marshall Zellinger was in the courtroom.
Then it is riot.
How would you define insurrection?
Part of my whole thesis is that we can't define it.
The legal team for former President Trump argued in front of the Colorado Supreme Court today to get the justices to reverse a lower court ruling that Trump engaged in an insurrection. Trump won that lower court ruling that determined, despite insurrection, he was still eligible for the Colorado ballot because the 14th Amendment that could disqualify him because of insurrection did not apply to the president. His attorney's definition of insurrection got an audible response from one of the justices.
I think the duration has to be longer than 3 hours. I think the geographical scope has to be broader than one building. And you say, well, that was the U.S. Capitol. True. It wasn't the Pentagon. It wasn't. It was a singular node. The goal wasn't to nullify governmental authority and set up an alternative government.
Several questions need to be decided by Colorado's Supreme Court, like did Colorado courts have the power to hear the case in the first place?
Did the district court have jurisdiction is a pretty fundamental question here.
Colorado has enacted an election code that gives district courts, including specifically in presidential primary elections like we have here, the authority to conduct the qualification disputes.
The reason Trump's team appealed is because the lower court deemed him an insurrectionist and then argued that if voters choose someone to be president, that cannot be insurrection.
So if everyone chose an insurrectionist, Jefferson Davis, let's use that example. If Jefferson Davis ran a while ago, and the electors who were not themselves insurrectionists chose to put him into the presidency, that would be fine under Section 3, and that would be consistent with the purposes of Section 3.
That would be the rule of democracy in work.
Jefferson Davis being the Confederate president and Section 3 of the 14th Amendment being passed and ratified right after the Civil War. Clearly, the group trying to disqualify Trump appealed to overturn that lower court ruling that kept him on the ballot. But Trump's team appealed to nullify that insurrection part of the lower court ruling. I asked his attorney under what circumstances would they again appeal, this time to the U.S. Supreme Court.
If the Colorado Supreme Court decides that Trump should not be allowed on the ballot and the people should not have that opportunity to vote for him, we'll likely appeal that to the U.S. Supreme Court.
And attorney Scott Gessler told me they would not appeal if Trump is kept on the ballot, but the insurrectionist label is also kept on Trump.
It's fascinating, though, because the Denver judge decided, listen, this thing in the Constitution, this was just for the Confederate insurrectionists. Yet here the Trump team is in court basically saying, like, well, yeah, if America wanted to elect the Confederate insurrectionists, then they should have been able to.
And that's another part of this is the definition of what is the office of the president, and does that title fit under this part of the amendment? Because is the president an office of or an office under? It's ridiculous, the small language that has to be debated, because we can't ask the people from 200 years ago what they meant by that language. Yeah. Coincidence or irony, this has to be decided by the Colorado Supreme Court by January 6th.
Oh. Yeah, I don't know if that's coincidence or irony. I'm always bad on which is which, but I do know that if it's more than 3 hours, you got to call your doctor. Marshall, thank you.